Okay. Let's go ahead and we'll get underway. This is the House Judiciary Committee. It's Friday the 3rd of March. We have several bills where there are requests to withdraw them. And so I need a motion to withdraw. Let me just offer this. I'm happy to do all 5 of them as a group, withdrawn unfavorable, unless someone objects. Is there objection? Hearing none. There's a whole unfavorable consent withdrawn. All in favor of the unfavorable withdrawn for House Bills 754, 757, 858, 1018, and 1197, say aye. Aye. Opposed, nay. Motion carries. So those are all withdrawn unfavorable. Now, we have House Bill 18. House Bill 18 came out of the Civil Subcommittee. Yes.
We did pass 2 amendments on the bill. We spoke with our expert from the State Bar section who indicated there may be a technical amendment that is going to be required, so I'm going to ask to hold this until we can get that technical amendment resolved.
Okay.
Does that count as his hold?
You want to talk about, well, okay.
I can talk about it now if you want.
Why don't we do what it does now, and then we can do the technical amendment later. Delegate Cardin, tell us what it does, okay. And then we'll come back. So
there was a work group created by members of the bar along with interested parties to come up with a way to redraft the standard form for powers of attorney, and basically this is the product that came out of it, to make it easier and more understandable and clearer so that people who are taking advantage of this, who might not always be lawyers, will be able to do it in a way that expedites and doesn't leave open the possibility of more litigation. How's that for a general? I can go into details of the actual bill if you want. I mean, I will say that Delegate Hill had us meet with an expert from the State Bar, and they spent an hour and 29 minutes explaining it to word for word, and we do not need that. I think that we are able to manage it if with any questions.
We have now, or does the technical? Do we want to vote the amendments now that we have, or do we just want to take them all as a group? All right, so we're going to draft it all together. That's fine. Okay.
We're gonna print a reprint for everybody so that they can see it.
That sounds great. Well, you all have that to look forward to sometime, probably in the middle of next week. The vice chair just groaned about that. I don't know why. Perfectly fine. All right, House Bill 36. I've gotten several emails, both that said, a couple weeks ago that said, please move this bill. And then I've got an email today that says, please wait to move this bill. Yes, Delegate Cardin.
I did have a conversation with some folks over in the Senate. They are negotiating some amendments that are trying to bring peace in the valley there. They're very close, and they asked us to hold it. And then I did get a quick conversation with Delegate Lehman, sponsored the bill, asking to just hold it to see if they can come up with the amendments. So I'm going to ask. I
seem to have this recollection that there were amendments offered at the very last minute at Sine Die last year, and then they came back. And
I drafted those amendments, Mr. Chair, and asked them to try and come up with an agreement, and we're now here waiting to do this all over again.
Week crazy, so okay. But if you want to hold it.
Oh, I think next week's going to be crazy anyway, Delegate Cochran, and that's very kind of you to think about that. But having said that, it's very, very kind of you. We should all thank Delegate. Honestly, thank you for that. But if we want to hold it this one time,
Delegate Lehman asked, she wants to try and get the bill out, and she fears this bill will die in the Senate if we pass this way, which, by the way, if that's the way that we want to go, I'm okay with that too.
All right, we will wait till next week, and it won't be Friday. It probably will be Wednesday that we're voting next. So there's that. House Bill 50, we are secondary. So for those of us who are new to our show, we were secondary on this bill to the Appropriations Committee. who voted it out 19-4. The following were the four delegates: Greist, McComas, Mangione, and is it Heinebaugh or yeah, Heinbaugh. All right, that was close, but it passed 19-4. Counts. Is this making? All right, it's making Holly get up. But could we, just for the committee, could we ask what the bill does, please? Uh-oh. There we go.
Okay, this bill defines private education loan, and it requires for a private education loan collection action, including a small claim action maintained by a private education loan collector, to, regardless of the status, it just includes that when that proper documentation is introduced into evidence before they can collect on the loan. It came in as it was amended last year, so it is as it passed the House last year. It passed the House 109-30, and then we sent to this hearing delegates Cardin, Tomlinson, and Pasteur. So if they have anything to add on it. If you look at the bill, the definition of it is defined what includes private education loan and what is not a private education loan. And I can go through all that, but it's in the bill and it's quite extensive. So.
Eliminate folks having debt from private credit companies that really don't have the information, that don't
Yes.
have the documentation. And so the fraud of it, just
Yes.
trying to eliminate that.
And I'm not going to make a big deal, but I am just letting you know I'm going to vote against this bill because I don't think it's ready for prime time. I understand where it was last year, and I have done a little bit of research, and having a little bit of experience in this area, there is a tremendous amount of documentation that's already required, and the enhanced damages provisions, basically, if you don't provide these 21 additional documents, which are, for all intents and purposes, already they include affidavits that are going to be nearly impossible to provide. You're basically absolving people of debt that took debt without having a real opportunity to litigate. And I just think that I think that having done it, I'm going to vote against it, but I just wanted to make that clear.
Let's do this before we get into further discussion on the bill. I'd ask for a motion. There's a motion for a favorable in a second. Okay. Now we can go to discussion on the bill. Delegate Conaway.
Thank you, Mr. Chairman. Delegate Pasteur, can you explain what you meant by a fraud?
Yeah, where the company that offered the loan really does not have the documentation that they go to court with when they are trying to recoup their money, and sometimes offering higher interest rates. That wouldn't be a part of the fraud. Higher interest rates than the public or the school might give to the student, but claiming that they have documentation to show that these people took out the loan and how much they owe, what the arrangements were when they really don't. So in the bill, they're asking that that the companies actually have to show the documentation, which I admit I didn't understand because I don't know how you get that far without having some kind of real documentation. So that was a question for me. But throughout the bill, she does use the word fraud.
So now you do understand how you get that far?
No, I really don't. I
still
still don't. I'm going with, you asked how I saw that. I was giving that in terms of the bill. But I don't know, and anyone may feel free to explain to me how you get as far as to having to take someone to court and you know you don't have the appropriate documentation to prove that they ever signed that contract with you.
Thank you.
You're so welcome.
Thank you. Delegate Cardin, you said that there are 21 things that are listed in the bill that they'd have to show. What wouldn't they be able to provide? What do you think would be difficult?
So first of all, it has to be provided at the first moment that so you'd have to be able to provide all these things before you can start litigation, not at the time of trial.
Right.
That's the way that the bill says it. It has to be at the Friday at first collection attempt, the initiation of litigation, and at any time that they ask for it. So you're talking about documents that could be as much as 100, 200 pages of documents, and you'd have to provide it every time they ask. So that it seems to me to be superfluous. But they include, among other things, all communications, including the date and time in the immediate preceding 12 months of all communications, all settlement communications, which for those of us who do go into civil procedures, generally speaking, you don't provide settlement communications in front of a judge, but you have to be able to provide all of that at any time during the litigation process for the preceding 12 months. Conclusory statements of law are required by the affiant, which seem to be against the standard of the normal judicial standards.
Where does it say that?
So I'm basing off my notes. Let me go to the conclusory statements of law required by affiants on the legal issues. So you'd have to, the affiant would have to sign an affidavit stating certain things such as perhaps the date of the statute of limitations, other things that a judge would be able to look at and make a legal determination, as opposed to what the affiant is providing. And you usually do have to do statute of limitations.
But where does, okay, and where does it say that?
Hold on, let me.
So for the people, for the members of the committee, we're on page 5 of House Bill 50, and it starts the list of all the things that they shall introduce the following evidence in a private education loan collection action. So that sounds to me not that they have to have it at the front door, they have to have it while the action is happening. So during the case, the name and the owner of the private education loan, and I hate reading to people, but whatever. Yeah. The original creditor's name at the time of default, if they used an account number, the last 4 digits of the account number, the amount due at default, an itemization of the interest and fees, a record of the date that the private education loan was incurred in the first place, a record of, so in other words, at least in these first 6, the information about the loan itself and
right.
about, how much they took out, when the first partial payment was missed, a record of the date and time of the last payment, if applicable. So that should be information that should be available to the lender. Any payment, settlement, or a financial remuneration of any kind paid to the creditor by a guarantor cosigner. So if somebody else paid on the loan, they would have to indicate that. A copy of the self-certification form and any other needs analysis. Okay, so that's right. I mean, I'm struggling with why this information is difficult for the lender to provide. Because it would seem to be, if they own the loan, that they would have it during, I mean, what good would, my understanding in the private loan industry, especially student loan industry, is they sell these all the time, and they go to the next person, next person, next person. And if they're selling this loan and moving it on, and I'm almost done, and they're giving it to somebody else, isn't this all information that you would want when you bought the loan in the first place? And a delegate card.
Right, I would say, of course, I think that you would want to have all this information when you're buying the loan. I don't see any reason why you wouldn't, but you don't necessarily have the copies of all settlement communications made in the immediate preceding 12 months. You don't have.
Why? Why wouldn't you?
Typically aren't discoverable.
Well, I mean, first of all, you may not have them. You might not have them. Why would, if it was sold to somebody else
Within the last 12 months?
within the last 12 months, and they tried to negotiate some sort of settlement, but they didn't obviously come to it, and it was not part of the packet that was sold. I mean, I'm not saying that they wouldn't want it and they wouldn't have it, but they might not have it.
Caveat emptor appears to be popping into my head a little bit. If you buy a loan and you don't have all the information that you need to be able to collect on the loan, why?
But that's not what you don't need this to collect on the loan. You don't need all the settlement communications made in the immediate preceding 12 months.
Okay. I now see multiple
I mean,
questions.
now you do. Now you're going to need it. So this is going to be new.
Okay. There are more questions, and I've been talking too much. I'll go to the vice chair, and then I see Delegate Tolles and then Delegate Pasteur to maybe wrap back around again.
I maybe don't have a question. Thank you, Mr. Chair.
Okay.
But I'm like, what is this bill? Why are we having this debate on this? So I'm flipping through, looking at past versions and the witness lists that are posted online. Did anyone come in to oppose this bill in all the years we've had it? I don't see a single person with written. So you're apparently the only opponent to this bill.
Well,
I just want to.
Well, okay.
But I'm just saying.
It doesn't mean he's got it. Okay.
I'm just saying, I see no opposition to the bill. 2 years ago we passed this. It was 130-3 on the floor. Again, no opposition. The OAG's Consumer Protection Division saying it's a good idea. Consumer Report's good idea. No opposition.
Was there opposition in appropriations when you went to visit?
I believe there was opposition, but
There's none listed.
Opposition.
well,
No opposition.
Hold on.
I do
Delegate
remember.
Toll- all right.
I did not remember any oral opposition, but I thought there was written opposition. I'm looking right now, and there's no opposition.
Delegate Tolles, then Delegate Pasteur. Delegate Tolles.
Thank you. Sorry, I just took Delegate Pasteur's papers. It's all support. I don't see any her packet from the committee. So I was going to say that in the same vein as the chair, you can get information from individuals if they sell it. When they sell your stuff, they send over the entire packet of information to the new to the new, let's just say, loan servicer. They send everything because everything is electronic. And I just know this because I had to help someone with some documents, looking at their documents, some contractual documents, and it was sold to this new person. And then I was helping a senior citizen, and I asked them to look at everything that they received because they had just, this loan was just sold to them, and the senior didn't understand what was going on. They mailed her in the mail a copy of the original documents they received when they sold that to them. So I just wanted to kind of offer that they can, even though they sell it, you can obtain that information because once you buy it, you got to give them everything turns over to them. Yeah.
My concern that is that I think that if we're trying to absolve people's loan commitments, then that's the purpose of the bill. It seems like what we're trying to do is make it difficult to allow the creditor to be able to collect. That's what it sounds to me like we're trying to do here. Now, and if we do that, we're going to make it harder to qualify for student loans in the long run.
For private student loans.
This is all private. This entire thing is private. This has nothing to do with public loans at all. This is only for private loans.
I think, at least as I read it, I think it's more meant as an incentive for private loan companies to make sure that they're keeping all of the documentation and keeping it all together when they sell it from repeatedly from person to person to person, which is
you can make
the
that case.
bigger challenge. Which, I mean, first of all, just saying, there are lots of things where there are one or two people who vote the other way. There's delegate grammar. There's lots of things. There are lots of things where people do that. So not making light of that at all. That's why I wanted to press a couple of the questions. Is
Sure.
that I wanted to get into the weeds of it, I guess, a little bit more. Delegate Pesture. And then,
You done? Go ahead. Okay. No, you're fine. No, you're fine. No, that's okay, because I kind of jumped in on that. So originally, I was going to say that I think with this bill, we've seen a history in this country of loan servicers sell private education loans, sell the information, and then when it comes to whether repayment options or how much the person actually owe, it's like, duh, what are you talking about? I can't find that you paid $10,000 already. And so I think, this bill is an attempt to say that you have to be responsible for every piece of information, every document, particularly if you want to sue someone. And we know the history of what's happening with student loans in this country. So I think it's a good bill to try to eliminate some of this, I don't know what happens to the money you paid type of situations that's going on in this country. So I just wanted to kind of add that. Thank you. I appreciate you for that. Thank you.
Okay,
So much love. It's
not an
even secondary.
attorney. I read this as one who might have the loan. I take out a loan. I think this is how much I'm borrowing. Then there comes a time when they want you to pay it back. And they're going to, and suddenly, because they talk about the interest rate as well, and all of the things that support it, the documents that support it, go into that. Now you look at the interest rate and you see that what you're being charged is greater than you thought you were paying. Now you go to court, and because they did not have to have all of the documentation, so you go, and the judgment then ends up against you, and you're going to have to pay this amount back. So I saw this bill as a support, a help for people who are so anxious to get that money, that, as we often do in homeowners and et cetera, cars, that it's a safeguard. So when you go in, that private company has to have at the beginning, not somewhere down the road, but at the beginning, all of that documentation. And even though, as you pointed out, it might make it a little bit more difficult for that person who wants the loan, but okay, because you're going to have to pay it back. Let it be a little bit more difficult, and you have to supply more information up front to get it. But in the end, you will be safeguarded. So I saw it as a plus for the poor little folks who are just trying to make a way and go to school and get a loan, and the wolf is out there trying to take his little money.
No, I'm sorry.
What? Did you do that?
Thanks. I just want to make sure I understand what Delegate Cardin was saying. So, as I understand it, of course, they'd have to have the original loan documents that were signed, all that information. But the documents that they're really talking about that are allegedly missing are, like, if they come back to try and renegotiate those, like a failed renegotiation of terms. Is that?
That's part of what I read.
Okay.
They're partially like any communications that you might have had in the preceding 12 months with the loan servicer or the owner of the loan.
Right.
And those I called a guy who does this, and he said, this could be a packet of 250 pages, and I'm going to have to send it to them every single time they ask it. And then if I don't, there's possibility of if I don't have every single thing that he did not believe was necessary for them to demonstrate the loan, the ownership, the amount that was paid, the interest rate, and all the things that should be required, they could get treble damages against the folks, against not only the the company, but the litigator, I believe.
Okay.
So, to me,
Yeah.
it seems like, so basically, the way I read that, as looking from the consumer side,
Yeah.
I don't do that. I don't do this.
Yeah.
I kind of dabble in it, but, what's that?
It just makes it harder for you to litigate.
I don't do this
in the
kind,
end.
but I do other creditors write stuff, and I will tell you that it makes it harder for everybody to get credit when you create these, because
These
everybody's
hurdles.
going to be scared to go forward. That's the concern that I might have. But
Okay.
be that as it may, Mr. Chair, I tried not to. I was just saying I was voting against it.
No, thanks for bringing it up, because I didn't really understand what documents specifically they were talking about, and that really helped. Thanks.
You went to the committee and heard the testimony. You've got experience on the topic, and if we're giving you a hard time, it's just because we disagree. Delegate Williams, then Delegate Phillips.
Thank you, Mr. Chair. I'm going to start with the last point and then go back to the earlier point. So I just read the section with regards to treble damages, and it only kicks in if the creditor willfully filed an affidavit that's required under this section containing false information. That's when the treble damages would kick in. Otherwise, it would just be regular damages. So I think that's fine. I mean, because you have to show the willfulness of the false statements in the affidavit. So I don't really have an issue with that section. I was trying to see if on, right before it talks about the affidavit, and I'm looking, I think this is on page 7 of the bill, roughly around line 8, but maybe that, I don't know if that would satisfy your concern, Delegate Cardin, where it talks about the signed contract, application, or other document evidencing the student loan borrower's liability does not exist. A copy of a document provided to the student loan borrower before the default demonstrating that the private loan was incurred by the student loan borrower. And I guess my thought process, and maybe, I don't know if we need to maybe tweak this a little bit, if they don't have the settlement negotiation documents like you're stating, couldn't they just simply state to the borrower before they proceed forward with the collection activity, this is our documentation of the loan that we have. We don't have copies of any prior settlement negotiations, but this is the proof that we have. And if this debt still is not paid, then we are going to move forward with collection action.
So I think that's already
Right,
required
and I
in
think
law.
that's what's there. So I think that satisfies your concern about not having the settlement negotiation documents, because if they do this, as stated on page 7, line 8 through 12, then I think that would take care of not having that documentation.
Okay. Thank you.
My question may have been answered, because I like Delegate Cardin, I'm stuck on page, I guess that's page 6, lines 9 through 13. And if you're saying that page 7, let me look over there, addresses that, then I'm okay. Because in doing this type of, not necessarily collection stuff, but in any settlement negotiations in a business transaction, it is hard to make sure that you've kept track of all of the...
Oh, I agree. I mean, and I see this analogous to like foreclosure proceedings, for an example. When you do a foreclosure proceeding, you have to go through what they call this loss mitigation process.
Right.
And so you have to reach out to the homeowner or the debtor, however you like to describe him or her, and say, hey, you're in default of your loan. Here is your application if you wish to request loss mitigation, which is a fancy way of saying mediation. And if you request that, then we will sit and do the loss mitigation process. If not, this is the amount that you owe, and we may proceed forward with foreclosure proceedings, blah, blah, blah. And then under the law, you have to offer it again, even after the foreclosure complaint has been filed. And so I see this sort of analogous to that whole process. Yes, it's a little onerous than, say, what a credit card company has to do if they're trying to collect a debt. But I think this goes back to Delegate Pasteur's point that these are private loans, that we're trying to make sure that individuals who take out these private loans are not being subject to some type of fraud or being subjected to some type of other consumer, anti-consumer thing or whatever that we just happen to be seeing. So, yeah, it's a little onerous. I don't disagree with you, Delegate Cardin. Sorry, I didn't mean to elevate you there. Delegate Cardin.
Who said?
Oh, no, I don't mean.
I want nothing to do with that institution across the street.
Oh, that? Oh, well, I didn't mean that. I meant across the street.
I thought I did. I said across the street.
But I mean, I guess this is the public policy argument now. Do we want to put these extra protections in place for consumers who are reaching out to get these private loans?
So my thing is, yeah, you do want to. I mean, I like the idea of putting the protections in place, but what are we raising the bar? Particularly, all the other documents are just straightforward documents. Mm-hmm. Everything except for the negotiations are all pretty much straightforward, standard documents that would be in a package that you would provide. So I was just wondering why they put that in there. I'm sure there was some logic behind that. Somewhat like loss mitigation, as you suggested. I get it. But that was a little different because if I do respond to loss mitigation, then I do have to go to mediation.
Right.
And we're not saying that here. So I'll probably still vote for this, but that one does. I'm like Senator Carr. I mean, dang, I just did it too. We're all promoting. We're trying to get you out of here, man.
Tell Shelley that.
But I'm like Delegate Cardinal.
I'll tell my son.
Delegate Conaway.
Thank you, Mr. Chairman. What I'm trying to understand is why would the company have to show the 12 months of communication?
I think the thought process is trying to show that you've made a good faith attempt to resolve the debt with the borrower.
And generally, just because you make phone calls, does that mean that you've made a good faith attempt?
It doesn't specify the type of communication that's required. Let me scroll back to page 6 here. It just says settlement communications. It doesn't specify the type of communication.
Okay, and so really this bill is about what could be considered as fraud, but really when you get into a default type of situation on a loan, you might have extra interest, double fees, triple fees, late fees,
right,
all kinds of other fees that you didn't know about. So you might be looking at an extra $500 a month in fees just from transferring from the original creditor to the loan collector, right?
Right, and the bill talks about you do have to provide an itemization of how you got to that dollar amount as it relates to the interest, as it relates to the late fees, and things like that. That's spelled out in the bill.
Okay, thank you.
Vice Chair, then Delegate Simpson, then we're voting.
Thank you, Mr. Chair. All right, let me start at the beginning here. Nobody, including the people who represent the debtors for years, has showed up to oppose this bill, which we passed already, 130 to whatever. 3 oddballs, and I don't blame them for whatever things they found they didn't like in this. You're entitled. We're all entitled to our votes. But I think people should just be aware the industry was put on notice that these changes were being requested. Nobody from the industry, and you are all meeting their paid lobbyists down here, came to oppose the bill, and we brought it back again, and they are not opposing the bill. So let me start there. Now let me start on the policy that we're working on here. Does anyone know what it costs to attend Johns Hopkins University in Maryland this year?
Too much money.
$80,000 is the 2023 average cost for a family. 1 year. So, no, that's room and board and what have you. So if you put that on a private loan because you're ineligible, that's $320,000 for a 4-year degree. This is not a car loan. This is not a simple credit card loan. And so what this document is asking to do is to treat this more like a home loan. Show me the origination document. You're trying to collect. You're going to court and you're asking for all of the powers of the court. You had questions about whether those should include the arrest of someone. That's for a debt under $5,000. This is way over $5,000.
You're already required to show the origination document.
I'm just saying some of the added things in here are origination-esque documents. That is my point. That if you want to clone the policy logic, it is very comparable. Now, as to this business about, oh, they got to show 12 months of communications or whatever, you can argue or whether that's reasonable or not. Again, they didn't oppose this. But here's the kicker. It says you provide that or a statement saying the borrower didn't try to negotiate. You can just put a statement in and then avoid the 12 months. Why are we having this discussion? I don't know. But I think it's a good bill.
I like it when we have discussions. How is this bad? But I appreciate Delegate Simpson, I see you, and we'll come back. Delegate Simpson, oh my goodness, I missed that. Delegate Simpson,
Okay.
and many more.
Just to chime in that I'm looking at this, it's been an agreement each and every, for like 3 years. It's a consumer protection. It's even gotten quite a bit of press in the past. So I guess, yeah, I'm a little confused. And I'm not hearing specifically what you want to, what you want to, like, what do you want to amend it to make it?
Right, so.
Because for 3 years it hasn't really, and folks have said, yeah.
I mean, is that, I thought question means.
You want to answer the question?
Okay.
No, I think there will be people.
Sure.
Like, what do you want?
So, I asked about the 21 additional documents that are required, or documentation, additional documentation. And the response I got was, you know, this is an upstanding person who handles loans like from Johns Hopkins. And he said, you know, if they don't have fraud involved. I mean, if there's any questions, they're not pursuing this. They're only pursuing ones where they have the document, the origination document, the clear indication of who owes it, how much they owe, and then what they're doing. They feel as if they're already doing what is necessary and what is appropriate. And then to add these additional things is going to make it impossible for them to be able to provide all that information with what they're getting now. So it's going to change the way that loans are documented. There's no doubt about that. The question is, are we making it so that interest rates are going to go up, and I don't have specifics because I didn't go into that kind of detail. I just said I was voting against the bill, and the reason was because I felt like this wasn't ready yet from what I heard. So I mean, I'm not holding the bill. I'm certainly not holding it. But if somebody holds it and wants me to go back and get amendments, I'm happy to do that. I'm not suggesting we do that, Mr. Chair, and I hope that we can move the question.
Thank you, Mr. Chair. I would like to move the previous question.
Motion to move the previous question. Is there a second?
Second.
And a second. All right. All in favor of moving the previous question? This is new for some of our friends. That means we're getting to the point. I think that Delegate Boucher had a sign he was waving at me that said, vote. This is the procedural way of doing that. And in future could be challenging from time to time, but here we are. All right, the motion to move the previous question. All in favor of moving the previous question, say aye. Aye. Opposed, nay? Okay. The motion's adopted. We're on the motion for a favorable that was properly seconded. We've had discussion. We'll do a roll call. The Vice Chair? Munoz? Yes. Munoz, yes. Crutchfield is excused. Cardin? No. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? You're not coming back. Yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? We're in the middle of the roll call, Delegate Conaway. Thank you. Delegate Kaufman?
Yes.
Yes. Delegate Williams?
Yes.
Yes. $15. All right. Well, if you like the last bill, here's House Bill 189. There's a motion, we will get to that in a minute because we have amendments. There are amendments to 189, and I'm going to ask Claire to talk about the amendments. She spotted a technical issue.
So, yeah, this is just a technical amendment. When Delegate Tomlinson came to me and was asking a question about the bill, and when I was looking in the code book, I noticed that there's actually a companion statute to this, the one that's in the bill, 10105.1, which was also included in the 2021 bill that enacted these provisions. And so it's 10105.2, and it just basically says that when someone is entitled to expungement, the automatic expungement under these circumstances, the court has to notify them of their right to expungement by petition if they want to do that before the 3 years, before the automatic expungement is done in 3 years. And it contains the same problematic language. So I've just included that statute in the bill and fixed the language in that statute as well.
This came out of a discussion Council had with Delegate Tomlinson, and so let's do this. Could I have a motion to adopt the amendment? Motioned and seconded. Is there further discussion on the amendment? Not on the amendment? All right. All in favor of the amendment, raise your hands. Anybody opposed? Seeing none, the amendment's adopted. Now we're on the bill. Now? Where are you?
Yes, I move favorable, but
All right,
I do have a...
Before. Is there a second?
Second.
All right, favorable in a second. Now we're on the bill as amended. Now people have questions. Delegate Munoz, then Delegate Kaufman.
Thank you, Mr. Chair. Just to the Vice Chair, would you mind refreshing everyone's memory and explaining this bill to us as it is now amended?
Yes. Yes, I will. This bill was not my creation. In fact, it was assigned to the subcommittee last year, but I, in truth, probably didn't devote enough of my brain to digesting what the bill was trying to do, and I felt a little bad about it this interim, and so I sat down and read it, and I said, oh, this is actually a legitimate bill. We should pass it. So this is why I introduced it. So what is the bill? And it comes, I think, a little bit out of some drafting mishaps, I guess, from some work, and it wasn't Claire's work. This bill came over from the Senate, to be clear. And here's what happened. In 2021, there was a bill that we passed. It was Senator Obie Patterson's bill, and it attempted to create a policy of automatic expungement for those Marylanders who have a record composed only of not guilty charges on a set. So acquittal, dismissal, not guilty, or null pros, except a null pros with drug treatment. So if your set of charges fit this circumstance, meaning you are nothing that they threw at you stuck, every single one was knocked out as a not guilty, that the state, after a number of years, would take care of that for you and wipe off your record, and it would be expunged. So that's the policy. We voted it. We thought it was done. But one of the case captionings in one of the private books described our law in a way that was different than we thought we had passed. And so let me just read to you the sentence so that you understand what the problem is. We were trying to expunge crimes that were all not guilties or civil offenses under 560, I think that's marijuana, a civil marijuana offense, or a must-appear traffic violation. So those were the categories of things that we were trying to automatically expunge. Crimes, civil marijuana offenses, and traffic violations. Here's the way it was written. We are going to expunge a crime or a civil offense under 5601. So 5601 is that marijuana section of code. Are we saying we're expunging a crime or a civil offense under that marijuana law, or are we expunging a crime or a civil offense under the marijuana law? That's the problem. So it has to be reordered so that people understand we are talking about all crimes, not just crimes under this marijuana code. That's the bill. It restores the intent of the legislature from 2021 to automatically expunge charges from people who are fully not guilty of what they've been accused.
This is just a favor I'm asking of you because you're such a decent, good man. I'm asking you, and I believe that. What I'm asking you is, might you next session, for us non-lawyers in the committee, consider creating a glossary of common legal terms? Because a lot of these, and I bring this up because fortunately, I have a built-in tutor here, so I usually whisper to Nicole, what does that mean in English? What does that mean in English? But I have, and Claire is my, assistant tutor here too, but I bring it up because there are a lot of fancy law school words in here, so maybe for next session, the speaker assigned a lot of non-lawyers to the committee, so could we have a glossary next time?
I'd be happy to do that, and I think you'll also find that we're going to plan field trips in the interim. That one of them will be probably to a district court, one of them will be to circuit court, where you can see some of these terms being thrown around loosely by lawyers. And so you'll get a better sense of what happens on the ground. So there will be that. Delegate Valentine.
Thank you, Mr. Chair. My main concern about this bill, and I am for this bill with the acquittals, the not guilties, and all of that terminology, nolli proseques are far from a not guilty. In a lot of different circumstances, individuals could be not, the state's attorney may not pursue a case for multitude of reasons. So that is the only concern that I have. I'll give you an example. I know we talk about examples, a felony theft and a victim is no longer available, they pass away. That does not absolve them and make them not guilty. They just don't have a victim to prosecute the case. So that is my only concern with this particular bill. Thank you.
So building on top of that, not guilty means they went to trial, they came out the other side, and they were found not guilty. A null pros, or nolli proseque, means that the state decided not to go forward with it at some point during that, everything short of the trial, basically. Delegate, we did that. Delegate Munoz.
That's a really great point. Would it be possible to include an amendment removing the null pros?
Well, I mean, we're on the bill as amended. I think what the underlying bill did was it said that null processes were able to be expunged, and so that was the whole policy point in the first place. I think that there was discussion back and forth about whether or not that should be allowed to happen at that time a couple years ago, and so that may very well be why people don't vote for it now. But having said that was the underlying policy choice from 21. Delegate Cardin and the Vice Chair.
Thank you very quickly. I have been in court scores and scores of times where we've gotten a null pros, whether it's the evidence wasn't there, they had the wrong person, they decided, you know what, we're better off dismissing this for various and sundry reasons. So they, if you didn't get prosecuted, why should you not have be able to have I mean, why should you be treated differently than if you had? So to me, it seems like, you know, for whatever reason, the state's attorney decided, you know what, we're not proceeding with here. So that shouldn't automatically be treated the same way as you were found not guilty. I'm not exactly sure why. I mean, they made that decision. To me, it seems like that's pretty clear that they should be for this situation, not how they're treated in other situations, but in this situation, for expungement purposes, it would seem clear to me that a no pros would be more likely to be expunged because you didn't even go to trial for whatever reason. So I'm just
So I just want to be fair to the conversation since I didn't realize we were going to get into the weeds of this. This is a policy discussion. I mean, you know, if you go back to the old adage, innocent until proven guilty, I would firmly side with Delegate Cardin on this. They threw a bunch of charges at you and nothing stuck. They don't get to hang that on your record forever. I'm sorry, this is America. You know, like that's supposed to be how we do it. As to that policy question on the original bill in 2021, this is how the votes went. If you guys want to know about the partisanship, at least with that body, it was 47-0 in the Senate on the underlying policy, unanimous. In the House, it was 101 to 36. Okay, so I'm just being candid about that, okay? There you go.
Thank you, Mr. Chair. So I have a couple staffers. One of my staffers, she's the daughter of a former Baltimore County police officer. There was a case a couple years ago. His name was David Warren, and they had problems getting him in the city, and he came out and committed a crime in Baltimore County, and they finally got him. It wasn't on a big charge, but they got him. And I told my staffer to trace this guy's record, and this is what she came up with. He had 230 total charges, two counts of carjacking, 8 counts of drug distribution, 12 burglaries, 6 traffic offenses, 58 assaults, 1 murder, 66 firearms violations, 24 counts of robbery, 12 counts of reckless endangerment, 2 counts of violation of probation, 5 counts of false imprisonment, 10 counts of theft, and 24 counts of attempted murder. And a lot of these were no pros. This one particular case, he had attempted murder, no pros, assault, second degree, no pros, illegal possession of a firearm, no pros, firearm possession with a felony conviction, no pros, transporting a handgun illegally in a vehicle, no pros, illegally carrying handgun on person. So, I mean, I am not single-minded about the issue. I think at some point this becomes your record is not exclusively your record, and it becomes a part of the frankly just public information regarding crime and criminal justice. And this is one. This is the gentleman who he murdered a constituent of mine, and I had to talk to his family and you know, come up with some justification as to why this guy was out on the street. Now the sentencing and conviction is a whole different story, but for David Warren, you know, most of these charges didn't stick, and we're not talking about like hunting without a license or a stamp or whatever. These charges are the worst of the worst, and at some point I feel it has to become part of just public information so people have an awareness here. Thank you.
Delegate Grammer, if someone is charged with murder but is not convicted of murder, are they guilty of the murder? Okay. So what's the issue that we're talking about here? Could we turn on Delegate Grammer's mic? Thank you.
I think there's value in having for posterity a record that this person was at least charged with this crime, even if they weren't convicted. even if even if it was null prost. I think, and I guess this is why a lot of states don't do what we're doing or what we're attempting to do, is because there is value in saying, this is not a conviction, this person is not guilty, but this charge did occur, this prosecution was at least attempted in some way, shape, or form.
I guess I just have a question. What is the value? You said there's some value. What is the value of having this out there from here to perpetuity, that this person was charged with a crime that they were never found guilty of?
And I've talked this, and we all have value in looking at our criminal justice system, our public-facing databases. I have that rinky-dink bill that never passes where I kind of go over this. You could be hiring, you could, just want information about someone you have a relationship with. Maybe this guy's your neighbor. Maybe you are a lawmaker. Maybe you work in criminal justice. Could be 1,000 different reasons that a person could just want to have access to this information. Maybe you're just a student and you want to see, how does this work? Why do we have these cases? It's a legitimate question. Why is Mr. David Warren, why is he able to get to 230 counts before something sticks? And I don't want to get into the answers of what the question is, but it's a legitimate question. And passing this bill, you'll never be able to ask it. You'll never be able to ask the question.
So Mr. Warren was arrested, charged, let's just say attempted murder, when he was 18 years old. Mr. Warren is now 65 years old. And you're saying that this should still be part of his public record of something that happened, I don't even know, I can't do math, this is why I'm an attorney, 40 years ago or whatever the case might be. Because for what? I guess I'm just trying to find the value added for that to be on Mr. Warren's record indefinitely. Say he's trying to co-sign on a house for his granddaughter at 65 years old, and this pops up. What if he is trying to start a new career? He's retired from one job and now wants to get another job, and this is still on his record.
Right. Delegate, I am not single-minded about the answer to that question, but the question that we have before us today is, does everything just get washed away?
No, and I think we have stated, under our laws, everything doesn't get washed away. If he was convicted of that attempted murder charge, that is going to be there.
Right. Conviction, we could do a lot of different things here, but that's not what we're doing. We're saying most of the non-convictions are just going away.
Correct, because he wasn't found guilty of anything.
Just because you are not found to be guilty does not mean a thing did not happen.
People break the law all the time and they don't get caught. That doesn't mean that they're sweet and innocent people either.
I agree. Like I said, I am not single-minded on the issue. It's not a cake you can cut evenly. But you're just evaporating history here. And there is, for me, there is a line which I draw where you say it is no longer just part of the public policy choice is not exclusively your rehabilitation. Part of the access to this information, frankly, is public safety.
Questions still now, or further comments? I see Delegate Conaway, then Delegate Munoz.
Thank you, Mr. Chair. Delegate, how could the police charge a person for having a gun and then it'd be null pros if they had a gun? How does that happen? Or are you aware of how that happened?
Am I the defender, the anti-bill person here? I'm sorry. What is your question?
Yeah, you're the defender.
Because
you were the aggressor.
That's okay.
You asked why. Yeah, you asked why. So, have you ever heard of profiling? Have you ever heard of discrimination? Have you ever heard of
quotas?
They charge you with 20 things and you were just standing there?
Yeah.
They want to find out who you are,
Yeah.
what you're doing. You're living in the city. You made a good point of the fact that you finally caught the guy in the county, but you didn't catch him in the city, but you had 60-something charges, and none of them were processed.
Right.
How is that? That
How
shows
is
you that
that?
you have a problem with your system,
I
not
have-
with that person, with your system.
I
And
would-
then if you break the person down so bad that they can't get a job, where certain delegates going to read about them and read their 60-something charges, what else can they do but go out and rob and rape and steal? That's what the Lord said.
I met a person, a very fascinating and interesting person recently after the election. And as you know, Ivan Bates was elected state's attorney. And I said, what is happening, was a person who was related to prosecution of Baltimore City. And this person said to me, the previous state's attorney would not prosecute violent crime. And I think that's how that happens, Delegate.
So you don't put all of that on the state's attorney?
No, I would find value in the comment that was made to me, and I would agree. And I think better clarity about why judges are making rulings, why there's so often probation before judgment, why you get so many crimes that are null pros. Is it a matter of you don't have law enforcement, so you can't find the evidence, so you can't make a good case, and that's why a crime?
Well, that's what I asked you. How could you not find a gun if you're going to charge a person with having a gun? I mean, that's a mystery to me.
You can't even ask the question if you don't have the data, Delegate.
Okay. All right, thank you.
Here's what we're going to do. Delegate Munoz, then Embry, then Young, then we're going to go. Delegate Munoz.
Thank you, Mr. Chair. Just quickly to respond to a couple of things. So I am overall a fan of this bill. But the null pros issue is an issue for me just because I have seen lots of cases thrown out, criminal cases, null pros for reasons of, limited resources, prosecutors' caseloads are too heavy. But regardless of all that, personally, I apologize for sharing another pharmacy story, but a day when my husband was not there, the pharmacy was robbed, and it was other staff members present, and we know exactly who those people were, and they were caught after some time and taken to court. And the guy who scared the two women working there with his firearm so much that both of these women no longer work in pharmacy because they were so traumatized from the event, he was null prossed because he was a very small fish in a larger drug scheme. And so just from my own personal experience and, the experience of these women that, we're close to and we really feel for them, I can't support expungement of null pros because what happens when he does something like that again and no one has access to that. And I personally am a big fan of shielding, but just not expungement for that reason. I think the courts and, the law enforcement system should be able to see that he participated, in this crime if something were to happen again. So that's just like a little personal experience.
Delegate Embry.
I wasn't planning to get involved in this debate, but something that Delegate Grammer said hooked me in. So I do support this bill, and I don't think that the hypothetical Mr. Warren should have. If the state cannot convict you, that's on the state. Shouldn't be on your record. I care very much about the data, though, because I think it makes it very hard to hold the system accountable. The state's attorneys, if null process disappear, then it's, you can't, there's no way to judge whether there's successful prosecution. So I've had conversations for future legislation with the judiciary and advocates to see if there's a way to have preserve de-identified data so that you're protecting the goals of expungement, but you still have the ability to judge whether there's the possibility, of holding the system accountable. So I just wanted to say that, but I support the bill as is. I think it's an important piece of legislation.
Thank you, Mr. Chair. Mr. Chair, question is with regard to the unit rule. Does that come into play here, and how might that impact?
Nothing in this legislation changes the way that we have a definition issue. Unit rule. When somebody is charged with something, so there's a criminal event, they might be charged with, let me pick on Dylan. So Dylan breaks into my house. he breaks into my house and he takes some things out of my house and then he goes and pawns them and we find out. And so, please don't. But having said that, he can be charged with burglary, with theft, and with malicious destruction of property. Well, not necessarily because he pawned, but he committed all of those crimes along the way. So all of those 3 crimes have to do with that one unit or that one criminal event. So it's the one initial act, and all 3 of those things are part of that initial act. What Delegate Young is asking with regard to the unit rule is what the way that we treat those acts is if you were convicted of something where if you're convicted of something within that criminal that unit, effectively you can't get the rest of it expunged until you can get whatever you were convicted of expunged. So in many cases, if you were convicted of the felony, you wouldn't be able to get that convicted for some period of time. So the other things tend to appear on your record. Even if you weren't convicted of the other 2, which is something that happens commonly, where if somebody's charged with 20 counts of fill in the blank, they might only get convicted of one of them, and the other 19 remain on his.
So let me make sure that. Sorry to take the committee's time. I just don't understand this. So I'm just trying to understand. So Assistant State's Attorney Kleppinger charges Dylan with 3 different things, but he only gets him on one thing.
Yeah.
Because of that, Dylan would have to wait. You have to wait till the most serious charge is eligible.
Whatever he was convicted of in order before. So if the state's attorney who handled the case prosecuting Dylan, and we're never going to do this again, if the state's attorney who was handling the case maybe gave him just a conviction for malicious destruction, well, maybe not malicious destruction, theft, that would be a lesser time than the burglary and go from there.
Okay, thank you for the education. It's cheaper.
So what was your question again? Your question has to do with the unit rule. Nothing in the bill doesn't address, it changes the way that we deal with the unit rule or anything. All this is a technical change, and it just makes a clarifying change. It is one of the vice chair's passion projects to do these technical change bills, because what can possibly go wrong? So here is one of them, and that is what he's trying to do today. Bless his heart. Do you have a question?
No, I'm thinking about the concern about no process, right? And certainly in circumstances where there's a conviction, the unit rule applies. So you wouldn't deal with the no process piece wouldn't come in where we're talking about these expungements there. So I guess what the point I'm getting to is, would this only really apply to A, where the unit rule doesn't apply, and B, where you're not convicted of anything, at which point I would argue at worst the shielding recommendation from Munoz could be a decent compromise potentially.
So this is existing law where he's making a technical change. It's not making a change to the underlying law.
Oh, well, I wouldn't roll it back. Just to be clear. No, I misunderstood and having a better understanding. Thank you.
I think people are watching us. I suspect they are. Although at this point, I'm not quite so sure they are anymore, because who would be? Delegate Taylor, we have, by the way, more bills. Delegate Taylor.
And I'm hoping this should be the final word on this.
All right, let's make it the final word.
Okay.
All right.
I choose to look at this from the positive. I think this is one of those cases where the negative screams and the positive whispers, we're so focused on those bad actors that we can't pay any attention to those ones that are trying to do good. And that's what this bill is for. It's helping those that have done well. Maybe they're looking to purchase a home or get a better job. But these things on their record, be they on their 5 years, 10 years, 45 years, are holding them back from accomplishing higher heights. That's what this is about. And I think that's why, and I know that's why I plan to vote yes on this.
So, okay, I think there was a motion and a second on the bill already for a favorable, and so I am, and favorable, did we adopt the amendment? We adopted the amendment. So we adopted the amendments, and we are going to go ahead with the roll call. The vice chair, Munoz, Crutchfield is excused. Cardin, Bartlett, and I'm not doing it the way I'm supposed to be doing, yes. Embry, yes. Pasteur, yes. Tolles, yes. Schmidt, no. Simmons is excused. Boucher, yes, and I can't help you with that. Phillips, yes. Tomlinson, Erican, Taylor, yes, sorry. Simpson, all out of sorts, yes. Grammer, no. Young, yes. Valentine, no. Conaway, yes. Kaufman, yes. Williams, yes. All right, I think it's 15-5. Okay, technical, simple bill. All right. And if you loved House Bill 189, just wait now for House Bill 226, which came out of the criminal subcommittee. Are there any amendments? Are there? There are amendments. Can we hear what the amendments do, please? From someone who knows what the amendments do.
Well, I'll give the very quick lay explanation. The bill takes existing law which prohibits sex between a camp counselor and, school personnel and their charges, and it expands it to include a range of things you see in the bill. Camp counselors, music teachers, things of that nature. But person of authority, excuse me. And the way it was drafted was a little too open-ended in places, and so Claire took a stab simply at preserving the sponsor's intent, but rewriting it in a way that she thought was not going to invite questions about unconstitutional vagueness or anything like that with respect to the category. So it wasn't a substantive alteration to the bill, but that's what
We don't have the
should have all
amendments in
been
the system.
emailed a reprint of the bill as with the proposed amendment.
Can people find the amendments, or does anyone not have the amendment who's looking to see the amendment? You don't have it? Yes. 226.
People are reviewing the amendment, which I've already read. I would like to be added to Delegate Moon's bill since it's being amended.
I will get to that here in a second. I want to make sure that we get to the substantive amendment first, but I'll make note that I have to ask if people want to add on. All right. Oh, you forgot to ask on 189? Yes. Let me get to that in a second after we do. Let me stick with one bill at a time. No, it's fine. I'm just trying to, one bill at a time. Do we have? It's sent today at noon. It is, it's not that late, but at the same time, we did have a long day yesterday. I'm happy to hold this on my own accord if people want to take a closer look at this and then come back Wednesday with it. And because this is an issue, or I'm happy to. Okay, I have some people not wanting that, so that's fine. We've heard this bill every year. Okay. No, I don't question that it's important. And look, in the history of this bill, this was an issue that I worked on, and with much consternation got something passed in 2013 when dinosaurs roamed the earth. So I'm at a point now where, you know, I'm not really looking to hold things up. I'm just saying I want people to feel comfortable with going forward. So anyway, we have the amendments before us. Yeah, that's fine. We'll move the amendment. There's a second. There's a motion and a second on the amendment. We'll have discussion on the amendment. People have questions or anything on the amendment thing? Delegate Cardin.
Actually, no, if there's no discussion, I'll just.
No, you're fine.
No, I was gonna explain what the amendment, try and explain what the amendment does. That's. But
Leave my seatmate alone.
I wasn't asking questions. I was gonna.
Well, he was going to explain.
Trying to explain that one of the things that we did to clean up this bill with this amendment is to make sure that if you have a person of authority at an institution with the victim and one of them leaves, it doesn't stop the ability for that person to be charged with said crime. Is that correct, Mr. Chair? To charge the.
Oh, go after the person.
Go after the person.
Oh, got it.
If there is already in the bill. Okay. Okay. I thought that was also the amendment was clarifying that as well.
Are there further questions on the amendment? Seeing none, all in favor of the amendment, please raise your hands. Anybody opposed? Okay, we're on the bill as amended. There's a motion for a favorable and a second. Discussion on the bill as amended. Seeing. Oh, Delegate Erica, I thought you were.
I just want to ask for a sponsor amendment. So do you want us to just, when we say yes to the bill, we just say and me?
I should have said that with the mic on. Is there further discussion of the bill? Delegate Grammer. All right, seeing none. The Vice Chair. Yes. Delegate Munoz. Yes, adding on. Crutchfield is excused. Cardin. Yes. Bartlett. Yes, and an add-on. Embry. Yes, and an add-on. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. And an add-on. Yes, and an add-on. Tomlinson. Yes. Erican. Yes, and an Erican. And an Erican. And an add-on. Taylor. I think that's what we're going to start calling it now. Yes. Yes, and an add-on. Simpson. Yes. Grammer. Yes. Young. Yes. Or I. Valentine. Yes. Conaway. Yes. Kaufman. Yes, and an Erica. Oh, God. Never living that down. Williams.
Yes, and
And
an add-on.
an add-on. All right. Passes 6, 8, 10, 12, 14, 16, 18, 20. With 20. Okay. All right, so now we're going to go back a step and ask for add-ons onto 189, which is Delegate Moon's bill. We passed it favorable with an amendment. I'm going to just go through quickly and ask those people who voted yes, presuming the people who voted no don't want to add on. Just saying. Cardin, Bartlett, Embry, Pasteur, Tolles, Boucher, Phillips, Tomlinson. Okay. Taylor. Add Taylor, Simpson. Add Simpson, Young. Add Young, Conaway. Was that? Yes, yeah, okay. Kaufman wanted to be added on. Williams. Okay. We're not voting against the bill. They were just voting on whether they wanted to be added on or not, and we're not going to ever do that again. All right. Okay, so now, House Bill 364. Could I have a motion on 364, please?
Move unfavorable.
There's a motion for an unfavorable in a second. We have discussion on the unfavorable. Delegate Grammer.
Well, yeah, I'll make my case briefly, Mr. Chair. So I'll ask the committee to think about Guy Powell when he talked about the value of expungement. He talked about his ability to bear arms, the fact that he needed to protect his family. I would ask the committee to think about the Marylanders who came to testify in support of State's Attorney Bates's bill when they told us that drug dealers were literally hiding guns in their front yards, and the culprits told them, if you tell the police, we'll kill you. So this bill is about the permitting laws, about what is required to carry a firearm in the state of Maryland, and it clarifies our laws by, frankly, getting rid of the permitting process altogether, which has been done in 25 states now. And I would ask the committee to consider the state, frankly, of our laws. We have a giant hole in our expungement laws that is being exploited by the state police to deny people who have received expungements. They're evidently being denied their right, not only the right to carry, but the right to a handgun qualification license. I would ask the committee to consider the fact that people who have, for the sole reason that they are qualified to use medical cannabis, they are being denied a right to buy a gun in Maryland. I would ask you to think about our laws over the past, 2 decades, where frankly the permitting process has been exceptionally political, and the laws in the state have been thrown out. I would ask you to consider the testimony of the state police this year, where they talked about, the spike in people who are now carrying via Bruin, and the fact that they haven't seen any increase in any tangible problems with the people who are now carrying. So I think, I gave you an example where I had to talk to a constituent about a death in a family via murder, and I'd ask you to think about those people and that we should give those folks some consistency in our permitting process, and that is if you're a law-abiding citizen, you can carry when and where you like as long as you do so within the bounds of the law and as long as you're permitted to own a firearm legally. So that's the reason I've brought this bill. This is done in 25 other states today, and they're trying to do that in quite a few more. So that's why I would ask for your consideration in this bill.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill. In your explanation of the bill, you spoke about the expungement law, and law enforcement was denying people their permits because of that. Can you expound upon that any?
Touch the button. There we go. Yeah, that was the bill we discussed the other day.
No, can you refresh my memory?
Yeah.
I was in a heated discussion earlier today. I forgot.
No, that's okay. So frankly, there's a loophole in that law. But it's the intent of the law that a person who receives an expungement, they're able to get a carry license, but currently the state police are denying them. And we're told they're also being denied handgun qualification licenses, even though they've got an expungement. And that's based on an opinion the state police have received, which speaks to the state of Maryland expungements, and they say they're not a true expungement because in some cases law enforcement can still get access to the records.
Oh, thank you very much for explaining.
Thank you.
Vice Chair.
Thank you, Mr. Chair. I'm just going to be very brief. I'm obviously well opposed to this bill. I will actually just point out, and I'm not being cute here, the lead Second Amendment group in this state is called Maryland Shall Issue, and I assume they mean shall issue a wear carry permit, so they're contemplating a permitting process. That's the lead, that's the name of the lead 2A group in this state. And if I look at some of the things you're actually trying to delete by getting rid of ground rules whatsoever, am I reading correctly that this would legalize people walking around with loaded handguns specifically?
Yeah.
I just want to understand.
So what the language in the bill is related to the permitting requirements. So if you repeal the permit, it repeals the related language therein.
Okay, that's not a world that I contemplate wanting to be in. Thank you.
Had discussion on the bill. I'm sorry, Delegate Erickson.
Yeah, thank you. Okay. Everyone who carries a firearm, almost everyone, I'd guess 100% of them, so those now 300,000 people, is carrying a loaded, likely chambered firearm. That's how you carry a firearm. If you do not carry it loaded and chambered, it is a paperweight. Because when you are caught with another gun in your face and you have to rack your gun to chamber your bullet, you are dead. So please, that is how all guns are carried, loaded and chambered, so that they are not paperweights.
All right. Is there further discussion on the bill? The motion is for an unfavorable. It is for an unfavorable, not a favorable, for those of us who are newer, so just making that clear. So if you're voting yes, you're voting to recommend unfavorable to the floor and the bill dies. All right. Roll call. The Vice Chair. Yes. Delegate Munoz. No. Delegate Crutchfield is excused. Delegate Cardin. Yes. Delegate Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt? No. Simmons is excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams? Yes. 13, the unfavorable passes. We have House Bill 440. It went through the Family Subcommittee. The chair of the Family Subcommittee is still recovering and I think is doing a lot better, although she still sounds not great, but she's doing okay, and I think she's watching us, and we hope that she continues to recover and know she will over the weekend. I'm fine holding on to this because I know there were a number of amendments that perhaps it would be better if the chair of the subcommittee were here. Yeah, are you okay? Look, well, all right. Why don't we do this? Let's go ahead and we'll work on House Bill 440. There were amendments that you should have received. Does everyone have? You should all have the amendments to 440. Are there? Can I have a motion on the amendments? Motion and a second on the amendments. All discussion on the amendments. Seeing none. Why don't you say what the amendments do, actually? Do you want to go to the mic right here and then, yeah.
Okay, the amendment revises the language of the bill as introduced to require a court in a custody matter to set an expedited hearing on a petition regarding a proposed relocation of a child if the relocation would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule.
Any questions or concerns about the amendments? Delegate Embry.
Recommended by the MSBA and Women Law.
Yeah, well, Laurie Root was.
Great, thank you.
what was said was that Lori Ruth from the Women's Law Center signed off on the amendments and that were being referred to by Delegate Embry. Further questions on the amendment? All in favor of the amendment, please raise your hands. Anybody opposed? Okay, we're on the bill as amended. Is there a motion? Favorable, and a second. Okay. Now, on the bill as amended, Delegate Cardin.
Thank you, Mr. Chair. Just quick, Lauren, as amended, the State Bar section, I guess, family law section was okay with it, right? Or did we not
They
get?
were not at the meeting, I don't believe, so I'm not sure exactly what their testimony was. But these are the amendments that conform the bill to the way it passed out of the Senate.
Okay, they conform the bill out of the way it passed in the Senate. Okay. I'm assuming then they did their due diligence there, Mr.
I believe that the subcommittee actually did a fair amount of due diligence, but if people feel in any way uncomfortable, I'm ready to, like I said, I'm ready to wait to actually vote the bill as amended on Wednesday. If people want to take a little time over it over the weekend, it's fine with me. You feel like that? Okay, fine. Then we'll come back to this on Wednesday, but we'll take it up as amended, and and it'll be better because hopefully Delegate Crutchfield will be back, and we'll be able to do that, and people can feel more comfortable. All right, that brings us to the end of the voting list. We have next week a potentially extended and special time that we will all spend together, as there are significant bill lists on Tuesday, Wednesday, and Thursday. There is a significant chance that we will have a voting session after bill hearings on either Wednesday or Thursday. There will be a voting list in all likelihood on Friday as well. So just letting everybody know that this is when we're going to get really into the teeth of it, and so I would encourage you to keep that in mind as we go through the next week or two. With that, we are adjourned. Thank you.